Yeah, let's. I got some stuff to say about that.
Ms. Martonzik, were you able to serve anybody?
We were not, Your Honor. However, if Mr. Moose will be in person at the September date, we can serve him at that time. We also have a publication scheduled.
Okay. Mr. Moose, are you willing to accept today and waive service, or are you wanting them to serve you in person or via publication?
Well, the thing is I got this document right here, and she copy and pastes the same stuff like 4 times. I believe that's fraud, and she does that just to make this document look like it has substance when it doesn't. If she had enough to take my son away, then she should have no need to copy and paste the same paragraphs over and over in this removal.
Sir, okay, so sir, can you just answer my question?
Ma'am, I've been dealing with so much fraud from you guys. It's hard for me to answer the questions because you guys always have these ulterior motives with your questions. I never get a straight answer from you.
Okay, Mr. Moose, I don't want to have to mute you. We've been through this before. Please, I want you to participate in this process and in this hearing, but I can't have you be disruptive.
Okay, no, I'm not. Okay, no, I'm not going to accept service.
Okay, all right, and Ms. Haywood, I assume you are not in a position to accept and waive?
No, Your Honor, and I would just ask that Mother respond to the emails that my assistant has been sending her so we can set up a meeting to talk.
Okay. And Ms. Haywood, if you want to file a written motion on your request to withdraw in compliance with in compliance with the rules, then you're free to do that. I don't know whether I'll grant it or not, but you're free to do that. Okay, so and then what about Ms. Arbalou?
Yes, Your Honor. My client will enter a denial at this point on the severance motion.
All right, so he'll accept and waive?
Yes, Your Honor. I provided a copy of the motion to my client.
Okay.
And Your Honor, for the record, he was served through counsel.
Right. All right, Sonia. So for all 3 of the parents, I'm going to read to you the Form 3. This is a form we read in all termination actions. Just as a reminder again that it's important to show up to court or we will proceed in your absence. This is something I'm legally required to read all the parents in these cases. You are a party in a termination action. If the court determines that termination of your parental rights would be in your child's best interest, the court may terminate your parental rights and your child may be adopted. Except as otherwise provided by law, court hearings relating to dependent children are open to the public. You may request that the hearings be closed and the court may order them closed for good cause. As a parent in a termination action, your legal rights include the right to counsel, including court-appointed counsel if you are indigent, the right to trial by the court on the allegations in the termination motion, the right to cross-examine witnesses who are called to testify against you, and the right to use the process of the court to compel the attendance of witnesses. You are required to attend all termination hearings. If you cannot attend a hearing, you must prove to the court you had good cause for not attending. If you fail to attend the initial hearing, the pretrial conference, status conference, or termination adjudication hearing without good cause, the court may determine that you have waived your legal rights and admitted the grounds alleged in the motion or petition for termination. The court may go forward with the termination adjudication hearing in your absence and may terminate your parental rights based on the record and evidence presented.
I demand a jury trial.